Hi, my name's Mark from Whiteacre Legal, and today's video is about retaining walls and Australian property ownership rights. Now, as always, please remember this video is made for information and entertainment purposes only, and it does not constitute legal advice. Your situation is unique, and you should consult a competent legal practitioner. Please don't rely on this video for legal advice. Okay, with that, let's get started. This area of law is particularly difficult because each factual situation is different, and the factual situation can change the legal advice that you get. That's why it's really important for your particular situation to get legal advice that's specific to your needs. In general, very broad overview, landowners often encounter a variety of what are known as hazards on their land, including collapsing retaining walls, landslides, or even rock falls. And really generally, often in the case law, we talk about the higher land or the supported land and the lower land or the supporting land. They use those terms. And as a really broad concept, the higher land or the supported land has kind of an obligation not to allow their land to slip or fall down to the lower land, but not always. And the lower land, there's no positive obligation on the lower land to support the higher land. Now keep that in mind. But what there is almost like a negative obligation not to do anything that removes that support from the higher land, if you can get that picture. So if I don't do anything, if I own the lower land and I don't do anything that removes the support, then I'm not responsible for holding up my neighbour's land. But if I start to cut away in my backyard and take away that support from my neighbour's higher land, then yes, there's an obligation for me to support what I've taken away. So keep those broad concepts in mind, but sometimes those obligations do change. Okay, so recent case law has changed this a bit and shown that where a retaining wall is currently in place and the higher land is not at fault and the retaining wall collapses, both parties might be equally responsible to reinstate that retaining wall, not just the supported land or the higher land. To put that simply, if you are the owner of the higher land or the supported land, you need to do whatever is reasonably required to retain your land. Now again, as in most case law and law, what's reasonable or what is reasonably required to retain your land? Well, if you've done what the court considers to have been reasonable to retain your land, for example, if you don't have trees that are sitting on top of the retaining wall pushing it over, or you haven't done something positive, or you're not negligent in some way, and the retaining wall fails and the supported land slips onto the lower land, well then both parties might be responsible to repair that wall. Why? Why is that? Well, often we just think of the supported land as getting the complete benefit of that retaining wall, but that's not necessarily correct, because the lower land also gets some benefit from having that higher land retained. For example, if we took the retaining wall away and the higher land naturally sloped down onto the lower land or slid or fell onto the lower land, then your use, if you own the lower land, your use of that lower land would be impeded, or you'd have less use of your backyard, for example. So there is some benefit in having the lower land to having that retaining wall in place. It doesn't just benefit the higher supported land, and everyone just assumes that it's the higher supported land that has the obligation to retain that land. But that's not always the case. Okay, let's look at what is reasonable, or what does the higher supported land reasonably have to do? And the courts will look at both objective factors and subjective factors when they're considering this. The objective factors that they'll look at will be things like what caused the hazard or what made the problem. They'll look at the probability that a personal injury will be suffered or neighbouring properties will be damaged if nothing is done about the hazard. Courts will look about the effort that's involved in solving the problem, and they'll also look at the expense of solving the problem. Some of these subjective factors that the court will look at are each individual landowner's financial situation, particularly their ability to afford a solution to the problem. The courts will also look at the size of the properties affected by the problem. They'll look at the time available to solve the problem and the age and physical condition of the neighbouring landowners. So when we're talking about this, it's important to go back to one of the fundamental cases, which is Leakey's case. In Leakey's case, the National Trust, this is an English case I remember, the National Trust owned a hill. Sections of that hill regularly slipped into neighbouring properties, including Mrs. Leakey's property, and I think she was an elderly lady. Mrs. Leakey pointed out to the National Trust that a large crack had opened up in the hill above her house and that there was an imminent danger of a major collapse of part of the hill onto her house. The National Trust did nothing about this problem, and some weeks later a large portion of the hill fell onto Mrs. Leakey's property. Mrs. Leakey then asked the National Trust to remove the fallen soil and debris, but the National Trust refused, saying it was not responsible for what occurred. So remember, we've got objective factors here, the hazard, what they did or what they could have done to resolve that hazard, the positions of each of the parties. Mrs. Leakey went off to court and obtained an injunction requiring the National Trust to remove the fallen soil and debris and to prevent further slippage onto her land. The court ultimately held, having regard to all of the circumstances of the case, particularly the subjective factors of both parties, that the National Trust had a duty to take reasonable steps to stop soil slipping from the hill onto Mrs. Leakey's property, and that duty made the National Trust responsible for doing whatever was reasonably necessary to prevent further landslips. In summary, the National Trust was required to do what was reasonably necessary to retain its land. So this might be where we get that concept of the higher supported land being responsible for retaining or supporting its land. We'll move on now to Carter and Murray. In Carter and Murray, a 100-year-old sandstone block retaining wall separated neighbouring properties in Balmain, Sydney. The wall stood on the higher property, but its face ran along the common boundary of the properties, and some of these sandstone blocks in the wall and soil from the higher land fell down onto the lower land, and it was clear that the wall was likely to collapse. Now importantly, vegetation, including 2 large trees on the higher land, contributed to the instability of the retaining wall, and this is often the case, that the roots on the higher land sort of burrow down and start to push the retaining wall over and threaten collapse. The owner of the lower land, in this case, obtained an injunction to restrain the owner of the higher land from permitting debris and rocks from their land to fall down onto the lower land. And the court in this case held that the collapse of the wall and soil from the higher land onto the lower land constituted a nuisance. Now that word nuisance has a specific meaning in property law, and only in property law. It caused a nuisance for which the higher landowner was liable from the time that she knew or ought reasonably to have known of the collapse or its likelihood under the principle laid down in Leakey's case. So again, we've got this reference back to Leakey's case. The court concluded that the threat of further collapse of the wall and the prospect of substantial damage to the lower land, so again we've got some of those objective factors, as a result of the collapse was sufficient to justify the granting of an injunction to prevent any further collapse. And in summary, the owner of the higher land had to do what was reasonably necessary to prevent debris from falling onto the lower land. Right, we'll move on to another interesting case of Macquarie City Council and Hicks. And this is an interesting case because the council owned a reserve in the higher land, which tended to slip, posing a danger to Mr. Hicks' property, which was the lower land. The council carried out some remedial works to stabilise the soil during 1984 and 85, but these were ineffective, and in 1988 council's engineer became concerned about further slippage and engaged a geotech engineer to provide recommendations for stabilising the soil. Now, in September 1989, council was told by that geotechnical engineer that unless appropriate remedial works were done, there was a high risk of serious and violent soil slippage, particularly if there was heavy rain, which could pose a risk to life. So cast your mind back to those objective factors. What are the things the court takes into account? Well, one of those is there a serious risk to damage to property or life? 1990, council allocated $300,000 in its 1990 works budget to carry out remedial works. However, before the works were done in this case, in February 1990, there was a significant landslip after intense rainfall, and that damaged Mr. Hicks' property. Now, the court in this case held that in all of the circumstances the council was negligent because it, one, didn't follow the recommendations of its experts. It made no significant response to continual complaints from neighbouring owners about the soil instability and the risk to their properties, and also even when it was compelled to obtain geotech advice, it didn't move quickly enough to implement that advice with any urgency. So again, in summary, the council were aware of the risk, they had the means to do something about it, and they took no practical steps to reduce the risk. So again, we have the owner of the higher land being responsible not to slip onto the lower land. Alright, now you might be sensing a theme in these cases that I'm talking about, but remember what I said above about all of the circumstances of the case as being important, and here comes the twist. So the next case that we're going to talk about is Yarra and Glenhurst Gardens. Again, a retaining wall on the boundary of two properties in Darling Point, Sydney. It collapsed. We had some big storms. I think this was around 2016 or 2014. We had some big storms in Sydney, a lot of heavy rain, and this wall collapsed and a whole bunch of soil and debris came crashing down onto the lower land, taking out a little cottage and a few other things. Fortunately, no one was injured. Similar to previous cases, the owner of the lower land obtained an injunction against the owner of the higher land, but in a point of difference, the court in this case, it held that the owner of the higher land still had a duty to do what was reasonable in the circumstances, to retain its land, but this did not extend so far to the owner replacing the retaining wall wholly at its expense. Now, importantly, in this case, the retaining wall collapsed as a result of old age, and ultimately the court in this case concluded that the higher landowner's duty with respect to the risk of further land slippage could be discharged by contributing half of the cost of the remedial work necessary to reconstruct the retaining wall, and by giving contractors access to its land so the work could be carried out. So there's the twist, where the collapse was nobody's fault. In this case, Yarra and Glenhurst Gardens, each party had to contribute 50% to the reconstruction of the retaining wall. We'll move on also to Malone, the owner's strata plan 4085 versus Malone. And again, this is another interesting case which kind of reverts what we've been saying before. Mrs. Malone in this case was an elderly pensioner with limited resources. Remember what we said before about looking at subjective factors as well. So objective factors, subjective factors. Here you have an elderly lady, limited financial resources. The lower land was owned by an owners corporation in Sydney, lots of money essentially. Rocks were falling from Mrs. Malone's land, and the solution to that problem was very expensive. It was going to cost a lot of money for Mrs. Malone to do those things to retain and stop all the rocks from falling down onto the lower land. The court in this case had regard to all of the circumstances of the case, including each respective party's ability to pay for the works, and concluded that Mrs. Malone was not responsible for solving the problem wholly at her own cost. The court held that Mrs. Malone's duty to eliminate or minimise the rockfall hazard was a measured duty which required her to use her best endeavours in cooperation with the owners corporation and others to find a reasonable solution to the rockfall problem. In summary, the circumstances of the case are important, including the ability of each party to contribute to the solution. Now, in summary, courts will take into account all of the circumstances of the case in determining who must contribute and in what proportion. So going back to what I said before, it's really this is a really difficult area of law, and it's really hard to give concrete advice to clients because it depends very much on the circumstances of each case. More recently, courts in New South Wales have not just imposed the obligation on the owner of the hire supported land. They've looked at all the circumstances of the case and looked at where the blame lies if a retaining wall fails and the capacity of each party to pay to fix the situation. As always, each situation is unique and you should get competent legal advice about your particular situation. Okay, so thanks for watching, and remember that it's always important to get good, competent legal advice about these matters and to discuss these issues first with your neighbour if and when they arise, often before commencing court action. The courts will require you to do that in any event. Okay, that's a very general overview of retaining walls. You'll see that it's quite a difficult area. For more videos like these, don't forget to like and subscribe to this channel. That really helps us with our YouTube metrics and helps us to make more of these informative videos for you. And as always, you can make your way over to our Whiteacre website to download a free copy of these slides that I'm working from today that accompany this presentation. Okay, take care and thanks for watching. See you next time.